Hello, everyone, and welcome to 247 Digitize Legal Support Services webinar on non disclosure agreements, everything you need to know. Before we dive into the agenda, a quick introduction to 247 Digitize. We are a US based company headquartered in Chicago, Illinois, with offices in India. For over 18 years, our international team has been optimizing and executing business processes with excellence. Our core services include legal support, data management, and bookkeeping. My name is Gagandeep Kaur, and I am a project manager at 247 Digitize. With over 11 years of experience in legal support services, I specialize in managed document review, having managed complex e discovery matters across various sectors, including financial services, regulatory investigations, employment related cases, and others. I also have experience in contract management, including contract abstraction and repository management. Joining me is Krishnaveni, a contract lifecycle management expert with over 15 years of experience. Her deep expertise in document review and litigation, combined with her strong leadership skills, make her an invaluable part of our team. She has successfully led large teams and is committed to deliver excellence through her wealth of experience. And finally, Sam, our technical expert today, brings 15 years of marketing experience across various sectors and hold an MBA with specializations in innovation and entrepreneurship. Before we begin, feel free to leave any questions you have during the session in the comment section and we'll address them at the end. Now I request Krishna Veni to take this forward. Over to you, KV.
Thank you, Gagan, for the introduction and appreciate the audience for attending our webinar. I will begin with the synopsis of today's presentation on non-disclosure agreements, which are primarily used to initiate early business conversations. Now you see on the screen is the index. We will go through the introduction to non-disclosure agreements, followed by purpose of the NDA. We will also cover exclusions to NDA and various types of NDAs that we commonly use. Also, you will learn the key structure in the NDA, along with best practices to be followed and common errors to be avoided. So, what is a NDA? A non-disclosure agreement, referred as NDA in short, is a legally binding contract designed to protect sensitive information shared between parties. It ensures that one party, the disclosing party, can share confidential information with another party, the receiving party, without the risk of that information being disclosed to unauthorized third parties. And how does NDA help? NDAs help to protect the interest of all parties involved by ensuring that sensitive information remains confidential. Execution of a NDA is frequently the first step in a customer engagement, such as before being granted the access to RFIs, which is the request for information, or court materials, or before business discussions can progress on a commercial relationship. Okay, let me give you an example here. A company might ask a potential buyer to sign NDA to share confidential information during merger and acquisition negotiations. In the next slide, we will go through the purpose of NDAs. The first one is the NDAs are used to protect confidential information being disclosed to unauthorized parties. This can help a business maintain a competitive edge by keeping its valuable information secret. NDAs can help prevent intellectual property theft by making it illegal for someone to use or disclose a company's confidential information without permission. NDAs build trust. Yes, you heard me right. So, signing an NDA demonstrates a commitment to confidentiality and builds trust between the parties involved. This is especially important in business partnerships, joint ventures, and other situations where confidential information may be shared. Well, investors are more likely to invest in a company that has taken steps to protect its confidential information using the non disclosure agreements. This can help a business attract the capital it needs to grow and expand. NDAs can be used to protect customer and client information, ensuring that personal data is not disclosed to unauthorized parties. This can help a business build trust with its customers and clients. We have covered all the points, and I would like to reiterate. In a nutshell, by protecting client confidential information, business can maintain a competitive edge, build trust with partners and customers, and attract investors to help them grow and expand. Well, I'll let Gagan walk us through exclusions of confidential information and various types of NDAs we generally use.
Thank you, KV. Now let's discuss the exclusions of confidential information. Specific instances where information is not considered confidential, even if it's disclosed during an NDA covered relationship. First, if the information is already public or becomes public without the receiving party's fault, it is not considered confidential. Second, if the receiving party already had the information before it was disclosed by the disclosing party, it does not fall under the NDA. Third, if a third party discloses the information to the receiving party without violating any confidential obligations, the receiving party is not bound by the NDA regarding that information. Lastly, if the receiving party creates the information on their own without using confidential information, the NDA does not apply to that information. Now, I'll walk you through the different types of NDAs, which can be tailored based on the context and relationship between the parties. First, unilateral NDA. This involves two parties where only one party discloses confidential information. The receiving party agrees not to disclose it. This is common when one party shares sensitive information, such as trade secrets or proprietary information. Next, mutual NDA. In this type, both parties exchange confidential information and agree to protect each other's information. It's frequently used in business partnerships where both sides have sensitive data to safeguard. Multilateral NDA. Here, three or more parties are involved. One party discloses information to multiple parties who all agree to keep it confidential. This type of NDA simplifies the process when several entities need to share information securely. Employee NDA. This is used by employers to protect sensitive company information shared with employees. It clearly outlines the confidentiality obligations during and after employment to safeguard company secrets. Last, consultant NDA. This type is employed when a company hires a consultant who will have access to confidential information. It ensures that the company's proprietary information is protected during the consulting relationship. Back to you, KV.
Thanks, Gagan. That was useful. Now, let's cover the elements of NDA. While drafting and reviewing NDAs, key clauses are to be considered. Let me walk you through one by one. The first one being the title that you see on the screen clearly states the non disclosure agreement. Then, introduction. Identify the parties involved. Usually, like I mentioned previously, it's the disclosing party and the receiving party. State the purpose of the agreement. Say, for example, to evaluate the potential business relationship between two parties. Definitions. Define key terms such as confidential information or disclosing party or who's the receiving party, so on and so forth. Obligations of the receiving party. Well, specify the obligations to protect the confidentiality of the information. Outline how the information can and cannot be used. Exclusions from confidential information. Going back to what Gagan stated previously, there are exclusions to confidential information, such as publicly available information or independently developed information, etc. List out what is not considered confidential. Next one is the term of the agreement. Define the length of time that the parties can disclose information. Let me give you a tip here. A standard NDA term is typically 2 to 3 years. I'm backing this with an example. This agreement shall remain in full force and effect for 2 years from the start date. Well, NDA may have a confidentiality period, or in some cases, they call it as the protection period, meaning the information must be protected beyond the NDA termination date. I'll state another example here. If the NDA expires on, say, December 31st, 2024, the confidentiality period may be hypothetically, let's take it to be 3 years, meaning the receiving party must keep the information confidential until December 30th, 2027. Again, no hard and fast rule here. It all depends on the preferences of the parties, the nature of transaction, and etc. Well, on the screen, we see the permitted disclosures. Specify any circumstances under which the receiving party can disclose the information. Usually, it's disclosed to its employees or for any legal requirements. Then we have the ownership of information. Clarify that the disclosing party retains the ownership of the confidential information. Governing law. This is very important. Indicate which jurisdiction's laws will govern the agreement. The last one that we see on the screen is the signature. Provide spaces for signatures and dates from the parties, both the parties. Now, Gagan and I will tread through the best practices to follow and some common errors to be avoided for effective execution of the NDAs. Let's go rolling, Gagan.
Absolutely, KV.
I'll begin with the do's, which is on the left-hand side. That's the best practices, and the don'ts would be the errors to be avoided. Use simple language. Avoid legal jargon and complex terms to ensure all parties understand the agreement fully. Clearly define what constitutes confidential information to avoid ambiguity. Use precise language to outline obligations and terms.
Complex language. Don't use vague terms that can lead to ambiguity about what information is confidential.
Limit the scope. Keep the NDA focused on specific information and purposes to avoid being overly broad. Exclude information that is already public or independently developed. NDAs become too lengthy.
Overly broad scope, like KV mentioned, avoid making the NDA too broad. It should be specific to relevant information only.
Right. Then specify the duration. Clearly state how long the confidentiality obligations will last. Consider the nature of the information when determining such duration.
Inadequate duration. Don't leave the duration undefined or make it too short, as it can lead to confusion about how long the obligations last.
True. Outline obligations. Clearly define the receiving party's responsibilities regarding handling and protection of the confidential information. Include provisions of how information should be stored and shared.
Lack of exclusions. Ensure there are exclusions for information that should not be considered confidential. Failing to do so can lead to disputes.
Oh, and we want to avoid disputes.
Right.
Permitted disclosures, the next one. Identify circumstances under which the receiving party may disclose the confidential information. Like we previously mentioned, it could be for legal requirements too. Limit disclosures to necessary parties only, such as the employees or agents, and they are bound by the confidentiality as well.
Insufficient permitted disclosures. Don't neglect to outline permitted disclosures. It can create issues if someone needs to share information under certain circumstances.
Do include a governing law clause. Specify which jurisdiction's law will govern the agreement to avoid potential legal complications, and this is very critical.
What happens if you don't include a governing law clause? Omitting this clause can lead to complications in the event of a dispute. As KV mentioned, it's very critical.
State ownership rights. Clarify that the disclosing party retains ownership of the confidential information and that no licenses are granted.
Failure to address ownership. Don't forget to clarify ownership rights. This can prevent future conflicts over the use of the information.
Do ensure proper execution. Again, critical. All parties should sign and date the agreement and also retain the copies for their records to ensure enforceability.
Inadequate signature process. Ensure that all parties sign the agreement. An unsigned or improperly executed NDA can be unforeseeable.
Do include consequences for breach, and this is the last point we'll be covering. Outline potential remedies or penalties for violations of the NDA to deter breaches, and also clarify consequences that may include legal action, financial penalties, reputational damages, criminal charges, and how can I forget, even termination in case of employment agreements.
Exclude consequences for breach. There is no way to exclude the consequences of breaching an NDA, but you can include exceptions to the definition of confidential information or carve out the obligations that apply to confidential information. This may lead to potential implications such as ambiguity in enforcement, limited legal recourse, or trust issues. With this, we conclude today's session. We'll try to respond to any questions posted in the chat box if time permits. If you come across any queries later and would like to know more about us, please feel free to reach out anytime using the contact details displayed here and visit our website at www.247digitize.com.
Thank you, Gagan. Thank you very much, and KV as well, for a great session on non-disclosure agreements. I would like to remind everyone watching this video that it will be saved on our LinkedIn page, and it will also be uploaded into our YouTube channel in case you would like to see it again in future time. As mentioned earlier, please feel free to contact us with any questions you may have on the topic. We'll be very happy to help you. We're going to take a couple more seconds to give you a chance to ask any questions. And remember, you can comment the video and we'll be able to see those comments. Okay, so we'll give you just a couple seconds.
Yeah.
I think that's about time. That's it for me. Thank you very much. And back to you, Gagan.
Thank you all for your valuable time and stay tuned for upcoming webinars. We appreciate your participation. Thank you again.
Thank you.
Thank you very much.
Thank you all.